Lisa, help us understand the implications of this memo.
So the implications of this memo, Alicia, I think go far beyond congressional investigations because the timing is not coincidental. Right now, the administration, as you know, is involved in a fight with a number of law firms over executive orders that were targeted at them. The president was trying to restrict the ability of certain law firms that he viewed as stacked with his enemies from doing things like entering into federal contracts or even walking into federal buildings. And that litigation is ongoing. At the same time, the American Bar Association has sued the administration for what it calls an intimidation campaign against big U.S. law firms on the whole. And one of the things that they want in that litigation is communications between Trump, his senior White House staff, and two other people, Boris Epstein, who is reportedly involved in brokering deals with firms that didn't oppose the executive orders, but rather wanted peace with the administration, and Steve Bannon. And then here comes this memo, like a bomb on day one of Todd Blanche's official tenure, which basically says that the president has a right to shield from scrutiny his communications, not only with his direct advisors, but between and among him, his direct advisors, and outside private citizens who are providing advice to him, people just like Boris Epstein and Steve Bannon. That it comes in the middle of this litigation where the ABA is trying to understand how the administration went after certain law firms and what kinds of deals it struck with others. That is not a coincidence at all. This is the Boris Epstein Protection Act in a memo signed by the Office of Legal Counsel.
So is it your understanding that this is retrospective in addition to prospective?
It's hard to say, but right now, those parties are involved in a court fight that hasn't been resolved. So it is prospective in the sense that now the Department of Justice will likely go to this judge overseeing this lawsuit and say, well, it's Department of Justice policy to assert executive privilege, not only over Trump's communications with people who work for the executive branch, but also with respect to people outside the government who are advising the president in his official decision-making capacity. So in that sense, I think it will be prospective, even if the communications themselves happened some time ago.
Peter, let's talk about the timing. I want you to layer on to Lisa's analysis the fact that we are 84 days before the midterms. Does that suggest to you that the administration is potentially preparing for the possibility they could lose the House, maybe even the Senate, and that countless congressional investigations will follow? Or do you think this is, as Lisa said, about something much more specific and nefarious?
Well, it can be both, right? I mean, it's not a requirement that only be one, but I think Lisa's analysis seems right on. Certainly, though, it does, look ahead toward the future when they're going to face a lot of subpoenas, a lot of inquiries if the House goes Democratic. That's been the promise of Democrats as they're running this fall, to use the power of the majority, should they get it, to wield the gavel and begin oversight in a way the Republicans obviously haven't over President Trump's administration. And this opinion will give them ammunition. Doesn't mean that they'll win, but it gives them ammunition to try to shield some of those conversations. Now, this only works if a judge or if eventually perhaps the Supreme Court agrees. The executive privilege is not written in a very clear way in the Constitution. It only got, it's been interpreted in different ways over the last 250 years, most particularly during the Nixon Watergate era, and then again, I think during the Clinton impeachment era, to be limited, to have some, counterbalancing priorities that could overcome executive privilege. We'll see whether a judge accepts this idea that people who are not part of the government or somehow covered by executive privilege. Has never been the case in the past. And you imagine that if Democrats go to court over a subpoena that has been defied by the Trump administration, that there will be, litigation over this. Of course, that litigation could take forever, which is maybe part of the thinking here.
Right. Help me understand that, Lisa, which is, can the memo itself be legally challenged, or is it only challengeable if it is actioned upon?
I think the memo itself is not something that can be challenged because it represents department policy. It's not law. But to the extent that the department relies on the memo with respect to positions it takes in litigation, think about it as an exhibit almost that the parties are going to fight about. This is ripe right now before Judge Ali and the District Court of D.C. This is a fight that the ABA is having in real time with the Trump administration. Do I fully expect the DOJ to go before Judge Ali and say, hey, wait a second, those things we're fighting about? Well, there's a new angle here. The department is telling us, the Office of Legal Counsel is telling us, we can't even provide these communications if we want to because it's against department policy. I think Peter is absolutely right to say this is something that's going to extend the life of this litigation in a way that is the friend of the administration. You know, delay, delay, delay is Trump's number one litigation tactic, whether as a private citizen or as a governmental actor. Here we go again.
Let's bring into our conversation former U.S. Attorney and MS Now legal analyst Joyce Vance. Joyce, you sum this up as we now have another first for an administration, the AG as consigliere. Explain that to me.
Well, look, we have an attorney general who is unabashedly acting in the president's interests, and that's not the job. The attorney general is the people's lawyer, not the president's lawyer. But Todd Blanche was very clear about this. He believes that Donald Trump has a right to direct control of the Justice Department, and that means to direct his brand new attorney general.
Can you help me understand, Joyce, sort of how this functions? Similarly, differently than speech and debate. I mean, there are protections for members of Congress, legal protections as it relates to their work legislating. I'm not clear here on what is supposed to be personal and what is supposed to be official.
And perhaps that's the point here, is to blur the personal and the official, because that's the source of the president's immunity from criminal prosecution. He has immunity for his acts as President Trump, but not as candidate Trump or as private citizen Trump. And this is an effort to blur. But Alicia, it's important to understand that this was always going to be the next frontier in the expansive unitary presidency, because an important part of this memo is the assertion of the privilege, not just for the president, but for his staffers. That's a critical next step. And they will argue that that's essential, that the privilege is in essence meaningless if it does not apply to staff and by extension, even to private advisors.
I think back to Bill Cassidy defending his Blanche vote despite some, quote, existential anxiety. A reminder, here is what Senator Cassidy said on the Senate floor.
All considered, I will vote for Mr. Blanche. I'll be criticized for this vote. What's new? But the people of Louisiana can be assured that I worked hard to understand the issue and to make the right decision.
You know, he was asked by Margaret Brennan on Face the Nation why his voice cracked in that moment. And he said, it is an enormous responsibility that we as U.S. senators are tasked with to represent the people of our state. This is one of the most consequential decisions that Senator Cassidy would ever have to make. It has been, T-minus 24 hours, and we're already getting an indication that the promises that were made in that confirmation hearing have not borne out in action.
No, they haven't. But Senator Cassidy, it's really interesting, Alicia. I think about that speech. And at one point he said that one of the reasons he voted for Todd Blanche was because he did not want to thwart the progress that the department had made on issues of human and drug trafficking. And at the same time, Senator Cassidy refused to meet with victims of human trafficking, the Epstein survivors who sought an audience with him and his staff unsuccessfully. I can't pretend to know what's going on in his mind and whether he has buyer's remorse or not. But to the extent that he still had concerns when he decided to cast that vote, I can't imagine those concerns have been assuaged. If not, they seem like they would be exacerbated by the events of just the last 24 hours.
Well, speaking of the events of just the past 24 hours, Peter, in order to get confirmed, Blanche had to reassure all of these Republican senators, Cassidy included, that the so-called anti-weaponization fund was dead. I want you to take a listen to the president talking about that fund just yesterday.
The anti-weaponization fund, do you think it's still alive at this point? And are there any options that you're looking at to perhaps? Well,
that'll be up to Todd Blanche. He was our new, and who will be, I think, a great attorney general.
That's not a no. It doesn't sound like it's dead, Peter Baker.
No, I don't think anybody should assume it's dead until he's left office. Now, Todd Blanche did sign a piece of paper basically saying it was dead. Critics said that that's not legally binding. They could change their mind tomorrow. And there's certainly instances already where they have paid out settlements to people who were convicted or investigated in the past and had claimed that that was political persecution by Democrats, even though they didn't have this fund officially in place. That doesn't mean that, therefore, they won't find ways of doing it, at least in smaller versions without an official fund. And I think that's one of the things that caused a lot of trepidation on the part of Republican senators who were uncertain, like Cassidy, like Cornyn, like Tillis. And I think that, Trump has made very clear over the last 10 years that when he says something one day, it doesn't necessarily bind him for what he's planning to do the next day.
I keep thinking about the memo that has been issued, the claim that the president can assert executive privilege over conversations with private advisors. Can he include then the Attorney General Joyce as one of his private advisors, given that he is his former personal attorney? I mean, so many of the questions around Todd Blanche's confirmation and nomination were this question of what has the president directed you to do? Is the president actively directing the Department of Justice? If those conversations are now shielded, do we ever get to the truth of who is actually leading the Department of Justice?
Interesting, because it's clear under Todd Blanche's theory that Donald Trump can order him to do whatever Donald Trump wants him to do, and he must do that, whether that's indicting Jim Comey or indicting Davy Hearn over touching water in the reflecting pool. But the fascinating issue here is what conversations are protected and what are they protected from? Because this whole memo only has vitality, only has life in the context of a subsequent criminal prosecution. Mm-hmm. And what this memo would seem to do would be to prevent not just prosecution of Donald Trump, but of anyone else who's involved in interacting with him. After the original immunity decision, I think we used to joke among ourselves in the green room that if the president of the United States wanted to pull off a bank robbery, the way he would do it would be to plan it with his attorney general, because they would consider that an official conversation and protect it. But this expands that scope of privileged conversations much further and really far beyond the bounds that even the Supreme Court justified in its decision.